It is August 20th of 2026, and this is the Court Gallery. First up, Judge Simpson presides over a bond violation hearing where someone tries to blame a failed alcohol monitor on a sudden craving for vanilla extract. Later, viewer discretion is advised as Judge Hesselink handles a deeply troubling animal neglect case. The defendant claims a concussion caused a multi-week memory lapse. The facts suggest she's just a callous monster who deserves every book the judge can throw at her. Finally, stick around for far more frustration and fury without the tragedy. A defendant insisting on self-representation pushes Judge McNally's patient to the absolute breaking point with a serious attitude problem. Buckle up, ladies and gentlemen. All that and more starts right now.
Courthouse case of the people versus Mario Floyd.
Does someone please get Mr. Gray? Mr. Gray. Mr. Miller. Morning, Your Honor. Marcia Craich. On behalf of Mr. Floyd. Mr. Floyd, can you please state your name?
Mario Floyd.
Good morning, Your Honor. J. Grant Miller, P58658, also potentially representing Mr. Floyd.
Richard, this is your motion to withdraw.
Yes, Your Honor, it is. There has been a breakdown in the attorney-client relation to the extent I can no longer represent Mr. Floyd.
What's the breakdown?
The breakdown is, well, if I may approach, Your Honor.
Approach. Record should reflect in the case really set for a competency today. As to the motion to withdraw, given what's been stated to the court will grant the motion to withdraw. Managed sign counsel has assigned J. Grant Miller to represent this defendant. As to go ahead.
Thank you. We are set today as the court set for a competency review. People are in receipt of a report from the Center for Forensic Psychiatry that applies to the defendant competent to stand trial. We would stipulate to the admission of that report, but I understand the defense counsel is refusing to stipulate to that admission and is going to seek his own independent evaluation.
Your Honor, I was handed a report this morning and I met with Mr. Floyd yesterday, so I'm very fresh on this case. But reading through this report and how it was written, it's my belief that the examiner completely ignored my client's diagnosis for ADD, ADHD, because the entire report reads like he had those conditions and she found him to be difficult. I've already talked to assigned counsel services and was given the name of a Dr. Colin King and a Dr. Schaefer.
How long are you going to need?
We're going to need at least 60 days before I could get the approvals for him to even see the doctor, Your Honor. So
60 days?
60 days, Your Honor.
At the competency review, at least at this point, for October 22nd, I think. That's not available. October 29th.
Your Honor, I have a matter that is in person downtown in 15th. That cannot.
It is Halloween.
I'm sorry?
Never mind. You have an in-person downtown?
I have an in-person matter set downtown with Judge Garwood that cannot be moved, Your Honor.
Oh, sure it can. All right, but the next day is November 5th. November 5th.
Thank you, Your Honor.
2026, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor.
But he will plead guilty to the violation because he is responsible for the any content that he puts into his body, but it was not intentional. It was only intended to use marijuana, and we will provide, Your Honor. I don't think he needs to be locked up, Your Honor. This is something he can adhere to, Your Honor's conditions, and make sure that any future use is with Your Honor's approval and proof to the court.
And Your Honor, if I may have a moment, when I spoke with my client yesterday, he indicated there was an issue with his medical card. He has indicated he's obtained a new medical license and he actually pulled up the that new license.
What I say, I'm not worried about the THC.
I was going to request the court to send him over to community corrections to get him tested today to see if it's just the THC in his system now that he has his license and getting it through a legitimate source. Understanding if anything other than THC comes back, I understand where the court's going to want him to be staying.
Ms. Felton.
You know, the people didn't even bring up the THC. That's the least of my concerns, frankly. It is the cocaine, it is the fentanyl, it is the mistest, it is the disrespect. It is the way we treated community corrections. I'm very concerned and I continue to ask for a remand.
Judge, I do not believe that this was intentional, disrespectful, or any intention to use anything other than his THC. I think that if he stops purchasing his marijuana on the street and subjected to the dirty weed that he got, and now that he has his card, we're not going to have these issues. Judge, I would ask that you put him in jail if he violates again. After speaking with him, I do not think we're going to be here on any future violations. He doesn't use those drugs. He doesn't want to use those drugs. And anything in his body was purely not intentional. We shouldn't have this issue again.
Again, Your Honor, I would just request that the court is inclined to follow the people's recommendation. We afford my client a chance to go get tested at community corrections now to see if it is just THC at the point because he has his license, or if he's going to show dirty for those other substances.
His actions at community corrections. Mr. Johnson knows what I expect of him.
Yes, I do.
And very clear at that. We have gone round and round at times. And he understands that I have the expectation, certainly, that he not act in a certain way. What he did over community corrections was, but I will say this, when Mr. Johnson, my impression, when Mr. Johnson starts doing that stuff like that, it's because he's using. When he's not using, he's a completely different individual.
And Your Honor, I stand at a disadvantage here as I just met my client now.
May I say one thing? Possibly.
Go ahead, James.
Yeah, I know your expectations, Judge Simpson. I've been dealing with you for years. I haven't been in this courtroom in a while. I've been staying out the way. I haven't been in using. And back in the day, you know, the image you have, arguing, confrontation. Of course, you know me. That's not that. I'm not doing, like I said, I was using the marijuana, purchase it. I'm not making no excuses for none of my behaviors, nor the dirty drops or none of that. Because that, like he said, my attorney said, I plead guilty to the violations because I am or what I consume. But that day, I was going through with a relationship issue. So I was kind of irritated anyway. You know what I'm saying? But I ain't over there with community corrections dropping. I just dropped on the
Oh,
13th.
but Mr. Johnson, you can't tell me that by what you did.
Yes. And I
I
understand.
mean, you just can't tell me that. Saying I don't have any issues. These folks don't need to be treated that way. They're just doing their job.
And I totally understand that. And I apologize.
My other problem is maybe I buy what counsel's saying. If your test showed up,
Did you? I'm sorry.
you had just one. But you know, it's dirty on July 31st, it's dirty on the 12th.
And I dropped on the 13th, I believe, as well. After that. So, I'm willing to go over there right now. I know I'm clean. I know I don't do drugs. I know I ain't.
I'm not doing that today. I'm not gonna sit up here and mess around with you. You know how you're supposed to act. You know what you're not supposed to do. Know that.
Yes, sir.
You know, you also know yourself well enough to know that when you're using like this, that's when you start doing that stupid stuff.
Honestly, Your Honor, I'm not using. I'm not. I can go across the street. You could take me in the back, drop me. I'm not. I work every day and go to my kids' practice.
I will adjourn the probable cause conference in these matters to the 27th of August, 2026. So we're just gonna adjourn it out a week. But at this time, we're just gonna have to get it straight again, Mr. Johnson. I'm not playing. Bonds revoked, defendants remanded.
Your Honor, what time is the adjourned PCC on August 27th?
I set it at 9, but you'll get an email with the exact time block you're in. Likely about the same time block. Well, no, you'll be in the 9 o'clock block. Because he's in custody.
Thank you, Your Honor.
Thank you. My judicial anniversary. All right, that's what it was. You should have followed along, Mr. Allen. You know, you should just. And that one was over. Okay. Court just called the case. People versus Tia Daniel.
Good morning, Your Honor.
Good morning. Go ahead, put your appearance on, counsel. She's here.
If it please the court, Attorney Sharon Jones, P number 57113, on behalf of Tia Daniel.
Your name, ma'am?
Tia Daniel.
All right. And what are we doing today on this case?
Your Honor, we'd like to set this for a preliminary exam.
All right. Is all discovery complete?
That appears to be so. I've received the digital discovery recently, and I have the paper discovery, so I think I have everything.
All right. Bless you. Would people have their witnesses available to first? I would set. Doing. Shit. Hold on one moment. Mr. Allen. Counsel. Have you seen the community corrections report?
Your Honor, I did receive a bond violation report regarding the electronic monitoring. I did
You
discuss
did?
that with Daniel, yes.
Okay, well, let's deal with that first because this is concerning to the court, certainly.
Would you like me to begin, Your Honor?
Yes, go ahead.
Well, Ms. Daniels indicates that she was not violating the court's order not to consume alcohol, but we believe she perhaps did utilize something that may have resulted in a false positive on August 16th that evening. And Your Honor, she understands what the court expects of her. She doesn't have any prior history, to my understanding.
Hold on, counsel. And I hear what you're saying, and I understand you know with what your client is saying, but she's saying that vanilla extract, I'm presuming, caused her to blow a .073.
Well, Your Honor, I'm no expert on what might result in false positives. But I know that was a single incident, Your Honor, and she understands not to do things that might throw her compliance into question. We're just asking for the
Is
court to
she
confirm
really
that-
going to maintain that story to me?
I don't know, Your Honor, personally,
Hold
but
on a minute.
can't explain.
kind of-
I'm sorry.
Vanilla? It'll be a party. Go ahead.
I believe vanilla does have alcohol in it, if I'm not mistaken.
Well, then there's a problem, because if it had alcohol in it, she can't take it anyway. Doesn't matter. It doesn't have to be a beer or a shot of bourbon or scotch. She can't have alcohol.
She
But
understands. I'm sorry.
no, those are the rules. And then if she's gonna claim that it's vanilla extract that caused this, she just says vanilla, but she blows a 0.073 at 9:22. 20 minutes later, it's an 0.63. 15 minutes after that, she's at an 0.53. And then she decides she's not going to retest, which is
Because
also a violation.
I don't think she decided not to retest. I think she thought that those tests that she did, the retest that she did, may have been all. I know that she did go to bed. So Your Honor, it was a mistake on her part, and we're just asking for another chance.
I don't mind giving people chances if they're truthful with me. But if you're going to sit up here and say that this was vanilla, I'm not buying it. We'll hold a hearing. I won't set it for exam. We can hold a hearing next week on this.
If that's the court's
The client
preference.
wants to say something.
Okay.
Go ahead, man.
I did have a drink, Your Honor.
Then why did you have your counsel, first of all, why'd you then lie to community corrections? And then have your counsel up here trying to advocate for you and you lied to her?
I was scared, Your Honor.
You were scared? Should be. The one thing you shouldn't do is lie to any court, and particularly not this one. Here's what I'm going to do. I'm not going to set it for exam. I'm going to adjourn this probable cause conference out 1 week to the 27th, 2026, 9 a.m. At this point, though, defendant's bond is revoked. Defendant's remanded. Clerk calls the case. People versus Rio. Page Pollard.
Brian Boley on behalf of Mr. Page Pollard, who's approached the judge. State your name for the record, please.
Real the chance Page Pollard, Your Honor.
All right. What are we doing?
Your Honor, for purposes of the probable cause conference, I'm asking for an adjournment, to have some additional plea discussions with Judge Feltus. If I may approach, I have agreed.
Yes. We do have a violation report.
Yes, Your Honor, people are also in receipt of that. It does reflect the defendant has reporting for the test says July the 16th, he missed July 20, July 31, August 3rd, August 13th. I also note that there were previous missed tests on July 9th, June 16th, June 10 as well. This is of great concern to the people. I do also believe Mr. Page Pollard failed to appear in February of this year and was only rearranged in May. So this has just been testing since May, first brought back into the court process. I am asking that the court revoke this bond and remand it to the Washington County Jail.
Your Honor, I did get the violation report. Mr. Page Pollard and I did discuss it. He will admit to missing the tests on the 20th of July, the 31st of July, the August 3rd and August 13th. His explanation given to me is that he was suffering from COVID during that time, both he and his 3-year-old daughter. And that was why he missed tests. I will let you know that he has
For 3 weeks?
That's the explanation I have, Your Honor. He did indicate to me, and he does have emails that were exchanged with Ms. Dozier at Community Corrections, advising her of that. I will just point out that the test that's listed here as missed on June 16th does also show as excused, and he did show up then on June 17th for a makeup test. That also happened on July 9th, where that test was excused, and he showed up on July 10th to test, Your Honor. So even though there is a notation of those being missed, they were excused, and then he did show up the subsequent day to test. Your Honor, Mr. Page Fowler and I had a long discussion about what this court expects of him during for purposes of testing. I know he's prepared to go test today if the court would like him to do that. He has recently obtained a valid medical marijuana card. He's currently working. He works 3 jobs, does carpet installation. He assists his mother with her catering business, and he does DoorDash to support himself and his 2 children, the previously mentioned 3-year-old daughter that I stated, and then a 10-year-old son as well, Your Honor.
So there's a problem. On August 13th, got an email from Mr. Page Fowler that said, I took care of my warrant and this is my new court dates. I start back dropping whenever you need me to. On 8/17, they advised Mr. Page Fowler to report to Community Corrections for a random drug test. He failed to report.
He did not have a ride to get to Community Corrections to test that day.
Your Honor, I also neglected to mention, and I apologize, that 6/17 makeup as well as 6/25 and 7/1 were all driving.
Yes, that's why. They told him to get there. He got a warrant. Doesn't seem to me to be taking it real serious.
He was testing before this string of missed tests, Your Honor. I'd ask the court to give him one more chance to prove himself to this court. Put your hands at your side.
They gave him a chance. He got a warrant, told him to report. He didn't come in.
But the warrant wasn't for this. It wasn't from Community Corrections. It was from another jurisdiction that he addressed. That was the reference.
I take care of my warrant. I can come in and test. They told him. That was on the 13th. That was the email they received. He told them. They told him to come in on the 17th. Haven't seen him. I'm now sitting here on the 20th. He still hasn't been to test.
Well, I told him to come in here first, hoping that you may send him over there to test. So that's what I'm hoping.
He had an opportunity to go over. He didn't go.
We're asking for one more opportunity, Your Honor.
Give me 1 week. I'll adjourn this out to the 27th, 2026, 9 a.m. At this point in time, though, defendant's bond is revoked. Defendant.
Thank you. Thank you, sir.
Thank you.
Thanks, Judge.
All right, who do we have at the jail, please?
Soraya Burns.
All right, could I have the deputy there adjust the camera up just a little bit so I can see her face?
Working on that. Sorry. Good afternoon, Your Honor. Gabriel Matisse on behalf of Soraya Burns.
Thank you, Mr. Matisse. All right, that's great right there. Thank you very much. Appreciate that. We are here today on a sentencing that was adjourned from July 30th. This is on an animal cruelty, animal abandonment case. There was a plea, I believe, to 3 different counts. Counts 1, 2, and 7, all being animal abandonment, cruelty resulting in death kinds of cases. We've started the sentencing process, and then we made an adjournment to get some additional information. And Ms. Brucker, I believe you have a witness that's available for me today.
Judge, I'll be handling this one. I have Animal Control Officer Fitzgerald is here.
All right. Do you wish to question her so I can have some additional information about what happened at the scene?
I would, Judge.
All right. Ms. Fitzgerald, would you raise your right hand so I can swear you in? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right. Thank you very much. Mr. Fortier, your witness.
Thank you. Ms. Fitzgerald, where are you presently employed?
I am the director of the Otsego County Animal Control.
And how long have you been doing that?
16 years.
Would it be fair to say that over the course of your 16 years, you've responded to numerous sorts of animal neglect cases?
Yes, a fair number, yes.
If you had to guess, how many do you think?
I would put it somewhere between 10 and 15.
Okay. And have you also had an occasion over the course of your career to interact with veterinary clinics who are doing autopsies on animals?
Yes.
Okay. And do you regularly go out to properties to, check on animals and things of that nature?
Yes, welfare checks are a normal for us to do.
Okay. And I want to direct your attention back to, I don't remember the specific date.
May
But it would
8th.
have been May 8th. Okay, so May 8th, 2026. Did you respond to a property that belongs to an individual by the name of Soraya Burns?
Yes, I did.
Can you tell me about the circumstances that led you to getting called out to that property?
We were given information, my office was given information that there were dogs in the house and that a neighbor had information that there were dogs that a dog that had died that had puppies, and the puppies and the dog were buried on the property. I contacted the sheriff's department to assist with search warrant. And we went from there and got the search warrant and went out to the property.
Okay. What did you find upon first glance at the property? What did you notice?
We did see an area to the east of the door where there was dirt that was disturbed. Upon entering the house, it was, I don't want to say it was indescribable. It was a mess, and probably one of the top 3 that I've seen in that bad of condition. The smell, the stench just permeated the nostrils and was very strong urine and feces smell. There was no carpeting on the floor or anything. It was just the bare wood floor. There was an animal that I believed to be deceased. It was a bearded dragon in a fish aquarium type tank. The dogs were taken out before we were able to enter. There were 2 dogs that were taken off or outside and put in our vehicle. Just going through the home, there was no food or water accessible to the dogs that were in there. There was feces, urine on the floor, and it was disgusting.
Okay. What condition were the dogs in that you had removed from the home?
The dogs were skinny. Their condition was scored. One was a 5 out of 9 on the scale, and the other one was a 3 out of 9 on the Purina scale. They were, their coats were thin, very dirty. They were obviously not taken care of.
Okay. What about outside the home? You said you had seen a spot that looked like it had been recently disturbed in the dirt.
Yes, we dug up at that. We went to that site and dug up the body of a female dog and puppies, neonates that were buried there.
And what was the condition of the adult female canine that you removed?
The adult, obviously deceased. It had a bone marrow fat content of 0.16. Normal bone marrow for canines is about 59.4. So this was a 1.6. This was definitely malnutrition, severe malnutrition and starvation.
Did this dog, did it look to you like it was essentially emaciated?
Absolutely. I mean, it was very, very skinny. There was hardly anything to it. It was literally skin and bones.
And did the veterinarian do any sort of Purina body scale or body condition for that animal?
She did not. She did a necropsy on the animal and the 4 neonates. Like I say, she sent that. She also sent toxicology into the Michigan State University Veterinary Diagnostic Laboratory. And that's where it was seen that there was a 1.6% bone marrow.
Okay. What about the 4? I think you said there were 4 puppies that were in there as well.
4 neonatal canines, absolutely.
What was their condition like?
They had 3 of the 4 had the placentas attached to the umbilical cord or to the umbilicus. And it was they were emaciated, and it was the stench again made you gag. So.
And over the course of your 16-year career, you had mentioned that you'd been to several calls with neglected animals, right?
Correct.
Have you ever seen anything like this?
I have not. I had not seen a dog that was buried in this condition or the neonates.
I don't believe I have any more questions for you at this time, but the court and/or Mr. Matisse might.
All right, thank you very much, Mr. Portier. Mr. Matisse, questions for this witness?
Thank you, Your Honor. Ms. Fitzgerald, yeah, did you see Ms. Burns at the property on May 8th, 2026?
I did not.
And did you understand that Ms. Burns had not been residing at that property as of that period of time at that time?
I did not know that, no.
Okay. Did you see her in any previous welfare checks at the home?
The last time we had many previous welfare checks. And the last time that I actually made contact with her was on December, I believe it was December 30th. Because we had a welfare check at that point stating that there were no dog tracks outside, and there were no tracks, and they believed that she had not been there in a few days or weeks. When I did get there and I did see her, she would not let me in. However, she did say that she had just gotten home earlier that morning.
Okay, thank you. Were you able to determine when that the food or anything like that had been replenished in the home last?
No, not at all. There was a bag of there was an empty bag that was found on premise at the time of the search and seizure of the dogs. But that I couldn't tell how long ago, how long that had been issued to the dogs.
Did you also find a canine supplement container in the home?
I did.
Okay.
It was almost empty, but there was some white powder substance in the bottom of it.
And Todd Scott did have access to the property. Is that true to your knowledge?
I do not know.
Okay, I appreciate that. Just to be clear, you can testify what you observed at the property, but not who exactly created those conditions at the property. Is that a fair statement?
I know that the home is owned by Miss Burns.
Thank you. And had you heard anything about Miss Burns' condition at any point during any of this investigation?
I have not.
Okay. Thank you, Judge. I have no further questions.
Ms. Fitzgerald, how often had you been out to the property when Ms. Burns was present with her animals?
Like I say, Judge, we were called out there 4 different times in the last 6 months by neighbors. And the only time that I had met her at the residence was on the 30th of December.
Were the dogs that you found present, either alive or dead in May, were those the same dogs that were present in each of the other times that you were present on the property previous to that?
I believe so, by them coming up to the window and barking at me through the window, yes.
What kind of condition, if you could tell, were the dogs in on your previous contacts with them before the May contact?
I truly could not tell through the windows.
All right. Did the dogs appear to be energetic and barking and moving around as at least appeared to be relatively normal?
I would say that they did bark like if I went inside, they were going to eat me. So I would say that they were a little energetic, but I couldn't tell exactly. I mean, to tell you how that.
Yeah, no, I understand. I'm not asking for a microscopic analysis of what their condition was, but would it be fair to say that if you had noticed dogs that were emaciated on your previous visits, that you would have taken different action than you did in this particular case?
Absolutely. I did notice that there were no signs of the dogs being outside on those previous visits.
All right, that's all the questions that I have. Any questions by either attorney based on mine?
No, Judge.
I just had one follow-up that I forgot to ask.
Please.
Ms. Fitzgerald, did the animal shelter incur any costs by any veterinary clinics as a result of this case or this investigation?
Yes, we did. There was the veterinarian that did the forensics necropsy. There was a bill from her.
Is that in the amount of $677.80?
Yes.
Was that the only bill that was received?
Yes. Other than the dogs, I mean, yes, that was the only bill for that case, yes.
Okay. That's the only other question I had.
Thank you. May Ms. Fitzgerald be excused?
Yes, Judge.
Thank
All
you.
right, thank you very much, Ms. Fitzgerald. Appreciate your time here.
Thank you very much.
Any other witnesses or evidence, Mr. Fortier?
No other witnesses, Judge. I did send down, I believe it was earlier this week, flash drive that had the body cam video on it. I also had sent to Mr. Horrigan this morning a copy of that Great Lakes Forensic Consulting report. Mr. Matisse was also attached to that and confirmed that he had it. So that was the only other things that I had sent to the court.
All right, Mr. Matisse, did you have an opportunity to see that video?
Yes, Judge.
All right. I've had a chance to look at it as well, but I won't consider it unless you've already had a chance to see it so that you can argue if you wish to about that. And it seems to mirror the testimony that I heard from Ms. Fitzgerald. So I've gotten that information either way. I have had a chance to see the laboratory report from MSU talking about the bone marrow content that she's testified to as well. Have you received a copy of that, Mr. Matisse?
I did, Judge.
All right. What I'm going to do next then is simply ask each of the attorneys for their allocution at this time, and then I'm going to give Ms. Burns an opportunity to make any statement that she wishes to make about that as well. So, Mr. Fortier, your allocution.
So Judge, I don't really want to belabor the point because I know I spent a little bit of time at the original sentencing kind of talking about the case, which I'm assuming is probably what triggered the court to want a little more information on it. With that added, context that's been provided, again, I'm going to stick with my original request is that there be some jail time imposed on this. I also think that a term of probation would be appropriate. I would ask that the court order her not to be able to own or possess or care for any animals. I don't think I know the statute provides that the court may order a psychiatric evaluation. I'm not going to ask for that at this point. Because I think her not owning any animals would kind of cover my concerns. I'm also going to ask that the court order the $677.80 in restitution back to the animal shelter. And again, just some jail up front, I think would be appropriate as well.
Thank you. Mr. Matisse, your allocution.
Thank you, Judge. Given the testimony today, I believe this actually comports with what Mrs. Burns has been trying to tell the court. She's not trying to say that this wasn't her responsibility and that she did not care for the animals. What she was trying to say was that these animals, when she was damaged during her period of a concussion and some contusions from being assaulted, were not properly taken care of with her. And that's what we wanted the court to really hear. She has a bottle of supplements there for the animals. She does, I believe that's something that people do when they generally do care for their animals. However, in this circumstance, what we really wanted the court to hear was that Ms. Burns was injured during this period, and our officer, Ms. Fitzgerald, just testified that she hadn't seen emaciated animals prior to this. And so I'd like the court to consider that in the possibility that Ms. Burns was caring for her animals and then simply relied on people who did not come through and help when she was injured. And so that's what we're trying to get across to the court today, Judge. Probation, I absolutely think would be fantastic for Ms. Burns. And if the court wants to sentence to jail, I'm asking that be considered minimally. She's been putting her life together and trying to get things on track. So what we're trying to explain to the court here is that there was an event that we want considered as to why this happened to her pets. I believe that had that not happened to her, she would have been able to continue to care for her pets, but it was traumatic and it put a lot of burden on her, and she didn't do enough to check to make sure the people she was relying on were actually taking care of her animals.
Thank you, Mr. Matisse. Ms. Burns, you have the right to address me and let me know anything that, in addition to what's already been said, that you want me to hear at this time. So this is your opportunity, ma'am. Go ahead.
I believe Mr. Matisse covered it all. They were my responsibility. I loved my animals and I fell short of that due to my injuries. And I never intended for any of this to happen or to lose my family in this process. That's all I have to say, Your Honor. I apologize for the circumstances.
How long were you in the hospital?
I was in and out of the hospital several times. I was injured for 2 weeks. The date when I was actually incarcerated was the first time that I actually was physically capable of going into my house. I was puking bile and passing out from pain, and I could hardly walk straight, let alone carry my own body or take care of myself or my son. My family, my neighbors took care of us during that period of time. So for 2 weeks, I was severely injured, and I fell short for the rest of my family, and I apologize for that, sir.
So after the 2 weeks, how long was it that you were not in the home?
I was incarcerated for 3 days, and then I spent a couple of days to recoup after being incarcerated at a hotel. And did my work, and then I went back. So I was approximately out of the house for sounds like about a week in consideration with the 3 days of incarceration.
So you're injured for 2 weeks and you're incarcerated for a week. That's 3 weeks.
No, the animals, the 2 weeks, when my house was raided, from my understanding, by animal control and the sheriff, I was still healing. I was in a neck brace, sir. I was still puking and passing out from pain. I didn't get into my house till May 11th. They went in she said, what, May 8th she was in my house? I wasn't even unaware that they were in my home until I had gotten back. And my neighbors had told me that my house was raided and my animals were gone, sir.
So when did you leave your house? When was the last time that you were there before May 8th?
We had been staying with neighbors, but I went in every day before work and 1 to 2 times after work to feed the animals, to take them outside, to give them water and attention. I heated the house with my gas stove because I know you brought up that there was no electricity. I made sure my animals were taken care of the best of my capability. I had removed me and my children from the home because there was no electricity, and I was concerned about the well-being of my children, but I took care of my animals to the best of my capability, heating the house, feeding them, watering them. I was in and out of my house on a consistent basis to make sure my family was taken care of, sir, up until my concussion.
When was your concussion?
I have no idea. It was beginning of May sometime.
This was May the 8th.
I
They
was
took
struggling.
the dogs out of your house. So you're telling me that you're in your house on a daily basis to take care of your animals right up to the beginning of May?
Yes, sir. I had just started 2 new jobs. The last time that every time that I had gotten money from work, I was buying 2 bags of dog food at a time. My oldest girl, Jade, was suffering from cancer. She was the one I was giving the supplements to. I had been trying for 6 months to get her to gain weight, and animal control had verified that she had cancer. My son at our visitation had told me that they had verified it and they euthanized her, which rightfully so. I just wish she could have died at home with her family. I was doing everything for my animals, sir. I would never leave them there in that condition if it was anything that I could do about it.
Judge, real quick, if I could.
Yep.
Part of what Mr. Matisse had sent me in anticipation of sentencing for the case back in July were some of the medical records, at least in particular, the after visit summary for her, where I can straight up tell the court, yes, she was diagnosed with post-concussion syndrome. However, the date that she was evaluated was May the 6th.
I waited 3 days to go before I went to the hospital the first time because I felt like I wasn't going to be properly cared for. I had my own fear and inadequacy initially after getting the concussion. So 3 days after the concussion, I went to the hospital the first time. I got diagnosed with chest contusions, arm contusions, back contusions, leg contusion, head contusion, and then I was basically shoved off. And then the second time I went to the hospital, I had to be gurneyed out of the house in an ambulance. I had stroke-like symptoms.
When did all that happen, man?
I don't know the exact dates. I still suffer from short-term memory loss.
All right. Was it close in time to when you went to the hospital and had that evaluation done for your concussion?
Close in time to when I was incarcerated. I don't know, Your Honor. Honestly, I just know it's a big blur. I know I went to the hospital to get treatment. I know I was sick for a while, and I wasn't capable of doing my responsibilities for my family.
Anything else that you want me to be aware of, Ms. Burns?
No, sir. I love my animals, and I'm sorry.
All right. How long have you been in the jail now, if you know?
I came in mid last week sometime. So about a week now, I would assume.
All right. Thank you. Mr. Matisse, anything else that you want to let me know on her behalf?
No, thank you, Your Honor. We've covered it.
All right, thank you. Ms. Burns, I don't have any doubt that you had some medical issues or medical concerns and that you had to go to the hospital and that you were had some injuries and that on those particular days and maybe even up to a week period of time, the 3 days that you were incarcerated and the trips back and forth to the hospital, I don't doubt that you were probably not able to take care of your dogs and your animals then. But the video at the house and the testimony of Ms. Fitzgerald tells me that that set of circumstances that led to the dogs being that emaciated and dying did not happen in a few days or a week. It was multiple weeks, if not parts of 2 different, maybe even 3 different months that you failed to take care of those animals. The comments that I heard on the video about the stench and the eyes watering and the not being able to breathe, if you had been at that house on a regular basis like you told me that you were, you would not have, this is not your time to talk, this is my time. You would not have been telling me what you did today. The officers physically couldn't hardly go into the house. It smelled so bad. The urine and the feces made their eyes water and breathing difficult. So if you'd been there every day, you would have led with that. You would have known that this is not right. The fact that one of the dead animals went down from 59% body fat to less than 2% body fat tells me that that dog wasn't being fed for a long, long time. Either you're lying to me or you are intentionally trying to emaciate those animals. Those are the only 2 options for me to consider. You could not have accidentally done this. There is no possible way in the world that I can believe that those dogs died of emaciation, which is what happened to them, and that the circumstances that I saw at that trailer happened in just a few days while you were gone for your injuries. That is beyond capability of reality. So you are going to jail because you absolutely starved to death a female dog and her 4 puppies. She had no milk to give them. The medical testimony or the medical information I got from MSU was they were still attached to the birth stuff that comes from the inside of the womb because the mother was so emaciated. The mother didn't have any milk to give them because she was so emaciated. That's on you. You did that. And for that, you're going to go to jail. You're going to do that for 60 days. You get credit for the days that you have in already, but you're going to go to jail for 60 days so you can consider how terrible your actions were. You're going to be on probation for a year. There's a crime victim fee of $75, a justice assessment of $50. There's restitution to the animal shelter of $677.80. There's court costs of $300, a fine of $200, and a local charge of $15. There's $365 probation oversight fee. It's a total of $1,682.80. You can pay that over the course of probation. You may perform community service in lieu of some of those fines and costs at the discretion of the probation department. You must enroll in and successfully complete treatment and educational program. I want you to have a mental health evaluation and follow all recommendations. There is to be no contact, possession, or ownership of any animals while you're on probation. Do you have any medical conditions now, ma'am, that would prevent you from doing work camp?
No, but I need to get help for my concussions still. I have back issues and stuff from the contusions and stuff. I go into pain attacks, and I still pass out from pain. I have short-term memory loss. I wake up where I don't know where I wake up sometimes, and all sorts of stuff.
All right, then I'm not going to impose community service work or work camp because I think that would be difficult for you to do.
I don't care, sir. Just give me the work camp. Anything. I need something to preoccupy my mind, and it would be good for my mental health to be in work camp, even if it's only for a couple hours a day.
That's not how work camp works. You either do the 7 or 8 hours that they do, or you don't do it at all. So I can't do that to them. That would not be work well for you or for them. It's just setting you up for failure, and I don't wish to do that.
May I attempt it, please? If I get help for my concussion in my body and everything, and I can get the proper medication, can I please attempt doing the work camp?
You're still doing the 60 days in jail. You understand that, right?
Yes, I do, Your Honor.
This would be over and above that. Once you're done with your jail, you'd be allowed to be released without having to go to work camp under my current sentence. Do you really want to do more?
Wouldn't it?
I'm not letting you out early from jail to go to work camp.
No, I didn't even ask that, Your Honor. What do you mean by it would be doing more?
It would be 60 days plus work camp if I gave it to you. It wouldn't be 60 days in jail minus whatever time you could do in work camp. You'd be going more than 60 days. You'd go 60 days in jail, and then you would go to work camp. I don't think you really want to do that.
Okay, all right. Okay.
That'll be the order of the court. You'll need to report to probation once you are released from jail, and they'll set up the fines and costs and your mental health treatment requirements, and make sure that you don't have any contact, possession, or ownership of any animals. Any questions that you have, ma'am?
No, sir.
Mr. Matisse, any questions?
No, thank you, Your Honor.
That's all for today then. Thank you.
Jeremy Shaw, Jeremy Dwayne Shaw, 24W34431.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. It's time we consent to the matter being heard via Zoom.
Your name, sir?
Jeremy Dwayne Shaw.
So I sentenced him to pay restitution in the amount of $960. This was a fraudulent scheme case back from October 1 of 25. That was the sentencing date, it appears. Is that right, Heather?
I'm sorry, what was the date you gave, Judge?
October 1 of 25.
Correct.
And then Mr. Shaw failed to appear for sentence.
No, I was there. The Zoom, I was in custody, Your Honor.
Talking to your lawyer, right?
Your Honor, my client said that he was in custody for approximately 6 months, and then actually he had additional time, and he just got out on July 30th.
Well, if he was in custody for 6 months and got out July 30th, he wasn't in custody on October 1 of 25.
It's two separate times.
Two separate times,
Shaw,
correct.
listen to me.
I'm sorry.
A lot of people, and I got a big doc.
Okay, I'm sorry, Your Honor.
You're not going to just start interjecting here. Got it?
Yes, Your Honor.
So that's what I'm trying to tell you nicely. If he was in custody for 6 months and got out July 30, that means he got in at the end of January or beginning of February, which is 4 months after October 1 of 25. Why wasn't he here?
Correct, Judge. He had 2 times that he was in custody. He had a 6-month stint and a 4-month stint that he was in custody. And he maintains that he was in custody.
I'm supposed to take him at his word.
Judge, we do have notes in the system saying per Monroe County defendant has been released, and then defendant now in custody at Wayne County Jail. And it looks like we sent a writ, but I'm assuming he was never produced. It looks like.
Is he in custody on October 1 of 25?
That's according to our notes. That's all we have. It looks like according to our notes, he possibly would have been, but I'm not sure how we would look back to find that out.
Done better on this sentencing, Mr. Shaw. I could not have done better on this sentencing for you. I didn't order anything. I ordered restitution of $960. I didn't even order the 75 victims' rights or $50 justice assessment.
Thank you.
Well, thank you.
I didn't know that. I didn't hear the citizen. I wasn't there. I didn't know that. I just started working.
Wait a minute. That's what I guess I was going to order. I'm a little confused on this. What happened here? Why is he in front of me? I don't have all I have is I see we had a PSI. He didn't show up for that. And then we rescheduled it because he was still in custody on September 17th. I made a note he was still in custody at the Wayne County Jail. New writ to jail, bench warrant to issue when he didn't show up for sentencing. I see what happened now. My apologies. When was he taken into custody?
He maintains it actually. There was a time where he was in court in custody and he was disconnected from the Zoom and they were unable to reconnect. That's when he maintains that
that was citizen.
Tried to take every effort to correlate with the court's order, but was unsuccessful in doing
Not
so.
order
Based on
restitution. I must have just written that down. I didn't sentence him on October 1 in absentia. I wouldn't do that. That wasn't it. I just wrote down restitution was going to be for $960. All right, here's what I need to do. I need to set a bond and I need a pre-sentence report. We're going to do that, have probation do that, Heather, today. PSI, sentence date. I don't know why he didn't show up when he wasn't in custody. Does he work?
Your Honor, yes, he actually just he got out on July 30th. He lives with his aunt in Wyandotte, and he just got a job recently at Burger King in Lincoln Park. He has not yet got paid on that.
3,010% is your bond. Give him the earliest date you can give him next week. Do a PSI. Remember, probation has to generate that. So give me a date for next week. It doesn't.
I'm gonna lose
have
my
to
job,
be-
Your Honor. I can't pay
You
a
should have
bond right
thought
now.
about
No
that
money.
before you ignored the court, sir.
I didn't know him. I was literally dropped. We was going for sentencing already. PSI was
I'm
already
not-
done.
listen,
I was going for sentencing, and the court Zoom
listen,
got dropped.
Listen,
I don't have $300, Your Honor. I
well,
just
I'm sorry
started
about
working.
that.
I just
Listen,
started working.
Sure, he doesn't have.
I'm not going to argue with you, sir.
I'm not arguing with you either, sir, but I'm saying it wasn't my fault.
Well,
I didn't miss that
I'm
hearing.
sorry. Listen, stop interrupting me. That's what I'm doing. 3,010%. We're doing
I don't
a
have that,
PSI.
Your Honor. I don't have
Mr.
that.
Shaw, then I'm going to set 100,000.
It don't matter.
I'm
It could be
gonna set
100,
down
could be
the
a
line.
million. It
You're
doesn't
not
matter.
going to
It's
argue
$2.
with me.
I don't have the money, Your Honor.
Okay. Too
I'm going
bad.
to jail. I just got out of jail. I'm going back to jail.
Too bad.
Oh, yeah, too bad, man.
Give me a date, Heather.
Oh, hey, I'm
Next
withdrawing
week.
my plea too.
Knock it off.
I'm withdrawing
Turn
my
around
plea.
here
Tuesday.
right now, or I'm
Okay,
going to
I'm
have you
withdrawing my
brought
plea.
over right now.
Man, you ain't talking about nothing, man.
Did you hear what I said to
No, I
you?
didn't hear what you said. It's because it's bullshit. I was at that hearing. I
don't
and it got
care.
dropped on me, man.
All right. 10% will be the bond.
That's
And
fine.
if you say another word, I'm setting the sentencing for next December. You got it? That's all I need is one more word out of you, tough guy.
Not being tough, Your Honor.
Give me a date for next week, Heather.
We're pretty open to any day, Judge, as long as they get the PSI done.
Yeah, so we could do Tuesday. We can do Tuesday. Okay, let's do it Tuesday. Actually, this is
25th.
Woodhaven, though, and it is a restitution case. I should
Oh,
do
there
it
is
on Woodhaven Day.
That unfortunately we do not have Woodhaven because Judge Hessen's off next week and it's her Woodhaven day. We
Then
don't have
let's do it
Woodhaven.
on Tuesday.
Okay.
That's the 25th at 8:30 in the morning. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. This was a fraudulent scheme case. You'll be lucky if I don't send you to jail. That's it. Good luck. Better be more respectful next time, young man. I'll say that with all respect. Good
Yes, Your
luck.
Honor.
Thank
Sorry.
you.
I'm just
Rebecca
looking.
Ann Montez. Do I have Madison Guess here?
She's on Zoom, Your Honor.
Madison Renee Guess, 26F246621.
I'm here, Your Honor. I might be counsel for Ms. Guest. Ms. Guest, could you state your name for the record?
Madison Guest.
Am I letting these people show up by Zoom? Am I,
Judge, you did give her permission to appear by Zoom.
why?
She's breastfeeding. It was.
Okay, fair enough. Let me just check one thing. Probation did not notify the victim on this case. That's what they wrote. But all the items were retrieved, so it's okay. I took the plea to disorderly under 771.1. They don't typically show up on any of those. This was and they don't typically show up on any of these. So I'm going to go ahead and I'm going to sentence her. I did not order a pre-sentence report. And I'll ask you, counsel, if you have anything you would like to say on your client's behalf.
Thank you, Judge. If I may, Miss Guess is 30 years old. She has two children. One is 3 months old. She also has a 2-year-old. She's a stay-at-home mom. She is receiving Medicaid. She's got her whole high school diploma from Allen Park. And we'd like the court to consider that prior to sentence.
Are you married, ma'am?
No, sir.
How are you supporting yourself?
Basically my family. I lost my job at Ford Motor Company when I was pregnant due to being pregnant. And I'm currently in a lawsuit suing Ford Motor Company for wrongful termination.
You didn't really need the camping chairs, did you? You didn't
No,
need
sir.
a Toy Story Lego set, right?
So
you don't play
that was
Legos,
paid
do you?
for.
You don't play Legos, do you? Play Legos? You play Legos?
No, I don't, sir.
Who plays Legos?
No, sir. My son,
How old is your son?
2.
And you have another child? Okay, I got it.
Your Honor, I would ask the court if instead of a court work program, because of the fact that she's breastfeeding, that you allow her to do community service instead. If that's
Anything else that anybody wants to say? Ma'am, anything?
I'm very remorseful. I made a mistake, and it's not a mistake that I'm going to make again. There's no excuse for it. I did have a very rough day. I'm struggling with postpartum. If you could give me a little bit of leniency, you will never see me again.
You never got printed on this, right?
No.
Well, you have to go get printed, okay? 6 months probation. I'll take this under section 771.1. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You change your address, your place of employment, or home telephone number. You must notify probation. You have to report as directed. You are to appear at the Flat Rock Police Department by tomorrow, August the 21st, to get printed. That is an order. Do you understand that?
Yes, Your Honor.
That's by noon tomorrow. I'm filling out an order. We're sending that to them, so you have to go there by noon tomorrow. I'll give you that extra day, all right?
Your Honor, could I ask you a question?
Yeah.
Do you think that 6 months is a bit much for this? This is my first offense. I'm not in trouble for
you can
anything.
appeal if you want. That's what I'm setting. I believe that's what you guys agreed to. I wrote down.
No,
6
there
months.
was no
Ma'am,
probation.
ma'am.
Sorry. I
Let
was
me
just very
check.
unaware of the probation.
You thought it was just going to be a simple, sorry, we brought you in here?
No,
Prosecutor
sir.
wrote down 6 months. Prosecutor wrote down 6 months. You guys agreed to it. Disorderly conduct, they pled it down to from retail fraud. I'm not revisiting that. I would have covered that with you ad infinitum at the time of the plea. So that's what I'm ordering. 6 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must report to probation as directed. I'll take it under section 771.1. You're to appear at the Flat Rock Police Department no later than tomorrow by noon. No later than tomorrow by noon. You're to serve 8 hours of community service by October the 1st, and you are not to enter 27319 Telegraph in Flat Rock or any other Aldi's. So I'm writing down, you have to appear there at the Flat Rock Police Department by noon tomorrow. If not, you'll be show caused and a warrant will be issued for your arrest. Pay fines 50, costs 50, 75 victims' rights fee, $50 justice assessment. That's 2.25. Probation fees are 120 for 345. I will not charge attorney fees. 345 is your total. 8 hours community service. Stay out of all these, get printed by tomorrow, or serve 90 days and do your 8 hours community service. I'm going to give you a review hearing date, and that will be in 6 months. And if you are compliant, the case will be dismissed on motion of the prosecutor. But you do have to comply with every aspect of probation. You understand that, correct?
Yes, Your Honor. I
You
was
have
just
the-
very unaware of probation. I didn't agree to it. It wasn't discussed, nothing.
I would have gone through that with you, ma'am.
Nobody ever said
Ma'am,
anything to me about it at all.
Ma'am, if you think you're going to be able to go in and feed people and not be placed on probation, you're coming to the wrong place. I don't know what to tell you. This is what the agreement was. They gave you disorderly conduct with the retail fraud to be dismissed. If you thought I was simply going to say, sorry, we inconvenienced you, that's just telling me that you really are not taking this seriously at all. So I don't know what to tell
No,
you.
sir, that's. Mhm. I was just never informed of any kind of probation. I was told that I was just gonna have to pay fines and fees. I was
That-
not ever informed.
That is not accurate, Your Honor.
You don't need to say that. I know it's not accurate. I know it's not accurate. I know you would cover that with her. I don't know what to tell you except, you know, I can't tell whose signature that is on the front, but she signed the back. She signed the advice of rights. She indicated she understood her rights. She got a break from retail fraud down to disorderly conduct, which I'm not a big fan of, but I don't get in the way of what prosecutors do. So I don't know what to tell you. I'm sorry you're disappointed. Next time you don't steal anything, you won't have to be on probation at all. You know what I'm saying? So how much of this money do you have to pay?
I don't have anything currently.
How are you going to pay this? You better get your family to help you out.
I can. Could you maybe give me like 2 weeks?
Yeah, I'll give you 2 weeks. You sure you can have it paid in full by then?
Could I possibly be put on a payment plan?
Yeah, tell me how much.
Could I do $40 a month?
That's not going to get you through probation, and you're going to be on probation for 9 months. If you want to pay $40 a month, you have to pay $340 by the end of probation. 9 times 40 is 360. So you'd be on probation longer than 6 months. You want to be on probation longer than 6 months? I mean, I can change it to 9
No,
if you
sir.
want. Okay.
No,
I didn't
sir.
think so.
How much should I pay?
You pay $60 per month,
Okay.
beginning on September 1. All money due. All money has to be paid, so you're gonna have to figure out a way to pay more by February the 1st. The review hearing will be after that, Heather. So we'll give her a review hearing date. You give me
The
that date
review-
if you would.
That'll be February 18th.
So you can stay with that plan, but you have to pay all of your money by February 1 because I'm setting this for a review hearing on February the 1. I'm sorry, February the 21, you said?
February the 18th.
Oh, I'm sorry, February the 18th at 8:30. You wait there, probation will come on there and instruct you. They'll go in a break room with you. Do you have any questions?
No, Your Honor.
If you have any money, I'm sorry, if you have any problems paying the money, you call the court, we'll go on Zoom, I'll give you an extension, but just keep in mind, you have to have all your money paid by then. You're gonna have to figure out where you're gonna do your community service. That can be at any nonprofit organization, okay? Best of luck. Probation will be with you shortly. Just be patient. It's gonna take them a while. Thank you. Do you have another one?
I do have two, Your Honor.
Which one?
Mr. McCloskey, Charles McCloskey.
Shane Michael White, 26R514802.
Good morning, Your Honor. Peter Bernard, P784113, MIDC counsel for Mr. White. Mr. White, could you please state your name for the record? Stacking White.
When are you gonna get tired of getting yourself in trouble?
Yeah.
I mean, look at this record. It's first impaired.
It is. I know, I feel silly when.
How old are you? When are you gonna grow up?
I had a long stretch. I did real good for a while, man, with loosening some things.
Well, you just got convicted of another felony back in April.
I know it.
You're gonna get to face that judge as a result of this plea. On a probation violation.
I've been going back and forth with them, and they're tracking this case. And I go back there next week.
Gosh, life's so much easier if you don't get in trouble.
No,
It's hard enough, don't you think? I think it's hard.
and these things happen, and then you sit and think, like, why am I doing this to myself?
I know. They're recommending 2 years probation. Can't say I blame them. Go ahead. What do you have to say, Mr. Granada? Did you review this report with them? And are there any material additions, corrections, or deletions?
No additions, subtractions. The only thing that we would ask the court to consider is, and again, based on the information that I had, I didn't understand why it was 24 months.
Because he's got a criminal history that makes him look like.
He has no prior code of UI.
So what? He's got drug cases. He's got drug cases. He's been involved. He's gotten in trouble for everything. I mean, larcenies, drug cases, fleeing and eluding, aggravated stalking, malicious destruction of fire or police property, larceny, another drug. I mean, that's why. But I get it. You're his lawyer. I'm not arguing with you. I'm just telling you why they did that.
Your Honor, it's just that in my experience, I've not seen a 24-month on first OWI again.
Because most don't have 10 prior convictions, right?
I understand.
But go ahead.
Mr. White is, as I said, 39 years old. He's single. He is currently working at a construction company, Key Construction in Dearborn. He's been there for 5 years. He has attended 7 AA meetings, although he did not bring the sign-in sheet.
Why?
He can fax that.
Of course he didn't. Why didn't you bring your sheet?
It's in another vehicle. I got dropped off.
Where's your vehicle? With the AA.
That house.
What house? Go get it. You didn't go. Why are you telling your lawyer to get up here and tell me you went and you forgot it when you didn't go and didn't forget it because you just didn't go?
I've been going to Salvation Army.
Listen, I don't want to hear it. You're going to go get that sheet right now. I don't care if you got to Uber, walk, take a helicopter, a bicycle. You're going now to get that, Mr. White. I told you to bring it with you every time you came to court.
I understand.
Who's at your house? Who's at your house?
Mother.
Your mother drive? Does she have a valid license?
Yes.
Tell you she better help you out and drive it over here right now. I'll expect it to be here by 10:30 or 11 at the latest. Or you want to just admit you didn't go? You want to just admit you didn't go? Or do you want to make your mother drive over here with nothing? Or do you want to have her come over here and have me embarrass you in front of her? It's up to you, whatever you want.
I didn't go this past weekend.
You didn't go at all. You didn't go at all.
I went 3 times.
Well, all right. Well, how many times I ordered you to go?
Twice a week.
And I ordered that on July 23. And this is August 20th. 2 times 4 is what? 8. That means you're 5 light. Why are you telling your lawyer something and having come up in front of me and lie to me for you when I know that you were lying to me? I mean, I don't get it. I just don't understand. I must have something that says I am really stupid on my forehead. I have to. I must. I mean, I can read this stuff. I've been doing this too long. I've been here for 32 years, 11 before that. And I watched my dad for multiple years down in the other courtroom.
I can tell out judges I can tell.
I don't need you to start flattering me now. I need you to tell me why you're not complying with orders. Here's what I'm doing. I'm getting off this bench right now. I'm taking a 5-minute recess because I'm going to treat you still fairly, even though you just lied to me in a courtroom, which I find repulsive. The only thing worse than lying to me in a courtroom is lying under oath to me in a courtroom. At least you weren't under oath. That's perjury. But we're not in a bar here. We're not on some fun-filled vacation here. This is a serious place. When you walk in those front doors, this is serious. And you got a record that made me think, should I send the guy to jail? I don't care if it's a first offense. And then you lied to me. Now, what do you think that's going to mean? So I'm going to get off this bench. I'm going to take a 5-minute recess. I'm going to contemplate so I can be fair with you. But do not come in this building and lie to me. Court's in recess. Stay seated.
Judge. I'm gonna do this one really quick. That's Trombley's gonna.
Have a seat, please. Your name?
Shane White.
We already started this. I'm willing to listen to whatever else anybody has to say.
No, I don't have anything else. Mr. White, do you have anything you want to say to the court?
I apologize for that. I don't have any excuses. I just found myself in a hole right now. I'm dealing with a lot of the other case and just juggling things, and I do apologize for that. I'm sorry.
You seem like a nice kid, but you're getting yourself in a lot of trouble.
I had a stretch running real good. Something happened. I find myself in trouble, and
I hate to tell you, judges go back and look at this stuff.
a lot of that's prior to, I think, 2017. A lot of those charges that was back then. About the last 9 years, been doing really good. And just bad decisions, man. One bad decision cost you a lot. I do apologize for that, and I will make it to meetings.
20 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation immediately. You have to report as directed. No alcohol. No alcohol. No drugs, no marijuana, no illegal controlled substances. You're to submit to chemical testing, PBTs, and ETGs. I will cover that in a second. Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're going to submit to chemical testing, PBTs, and ETGs. I'm going to make that weekly for 2 months. If you're clean, then 2 months more, bi-weekly. And again, I want to be clear. This is a lot driven by your record. But I'm also recognizing this is a first offense drunk driving. So it's weekly for 2 months, bi-weekly for 2. If you're clean on those, then monthly. Attend AANA 3 times a week until you're in intensive outpatient treatment. Once you get in intensive outpatient treatment, you no longer have to attend AA or NA. I'm also ordering the Victims Impact Panel, which is 1 night, put on by Mothers Against Drunk Drivers. So far, do you understand the sentence in court? 300 fines, 300 costs, 75 victims' rights fee, $50 justice assessment. That's $7.25. Screening fee $60 for $785. Probation fees are $400 for $1185. You have cost of recovery of $150 for $1335 plus attorney fees of $40 for $1375. I'm ordering 10 days jail credit 1, 3 days now, 6 days on the court work program. And there's $210 in court work program fees. $1585 is your total. You may be eligible for early discharge if you're compliant. You have 21 days to appeal, 14 to apply for a court-appointed lawyer for purposes of appeal. If you violate again, you understand you could get 93 days, correct? All right. Can you pay all this today or you need time? Do you have anything today?
I'm like paying $100 today.
You pay $100 now, and then I'll set you up on a payment plan. Can you pay $50 a week or not?
Yes.
You pay $50 per week, and I'm going to start that beginning on September the 22nd. I'll give you some leeway, September 21 rather. You're in custody for 3 days. It's a small price to pay. I don't care if it's first drunk or not, and that's what I'm doing. I wish you well. Probation will instruct you. Good luck. Thank you.
Thank you, Judge.
You can have a seat right over there, okay? Shannon Jarrell Phillips, 261-50905A and B.
Sir, just go have a seat in the hall.
Your name, ma'am?
Shannon Phillips.
Ms. Foley Carter, your name?
Requiring about to touch it.
1 second. Why don't you write the ordinance section? All right, so look, I looked at the videos. You have to understand, you can't file motions 2 or 3 days before the hearing. Okay, you can't do that. She filed responses this morning, right?
It was last night, yes.
You filed one to one of her motions this morning. I gotta read those.
Okay.
I'm just telling you, you can't file a motion 2 days before the hearing and expect her to have ample opportunity to respond. So I'll reschedule those. The only one I'm going to handle right now is the motion to dismiss. And then I'm going to go on to one other little one, but you can argue your motion to dismiss. Now, Ms. Phillips, I want you to listen to me, please. I know you're not going to want to do this. It's okay. But I still am going to strongly encourage you to have a lawyer. I'll be happy to appoint you.
No, sir. And I'm gonna respectfully decline, considering that the last counsel that was forced on me suppressed my defense and wasn't any help. So I don't want an attorney. I can proceed by myself. And then I was going to ask for an adjournment because I just received 21 attachments, the rest of the discovery, the CAD logs, the use of force reports, the surveillance from inside the police station, just last night. And I requested that April 29th, and just got it yesterday.
Well, when did you fill out your motion? Let me just cover this with you. Mr. Pelland, would you have a seat somewhere else, please? Mr. Kimikai, can you have a seat somewhere else, please? Ms. Foley Carter, have a seat at prosecution table. Ms. Phillips, have a seat at the defense table, please. Ms. Phillips, I want you to listen to it. My father was a great judge. Told me 50 years ago, the lawyer who represents himself as a fool for a client. Now that's a lawyer representing himself or herself. I didn't force anything on you. I'm just telling you, you are going to be much better off. The main part of my function here is to make sure that you get a fair trial. Ma'am, please let me finish. That's what it is. Make sure you get a fair trial.
That's the same thing Judge Hesselink said, and I did not get a fair trial.
Ma'am, let me finish. You're getting angry. And that's one of the reasons you shouldn't represent yourself. I'm going to tell you something that you can believe or not believe. This is the greatest profession in judicial system in the world. There's not any better. Your anger is going to be so apparent to that jury. I'm afraid you're going to hurt yourself significantly. They're already going to see the video of the booking, which I observed, by the way. That doesn't bode well for you. And number two, if you showed the lack of respect in here that I sensed that you might have down there, busting into the judge's courtroom while she's talking to the jurors after the verdict and start yelling, you and I are going to have a very big problem. You have every right to represent yourself, but you're going to be stuck complying with the rules. It's one thing to take AI stuff and fill it out. Ma'am, let me finish. It's quite another to try a jury case. I don't know your level of education. I'm kind of impressed what you put together, but your anger, ma'am, your anger is going to thwart your ability to get a good, fair trial here. And I'm telling you, you can represent yourself. If you want me to have a lawyer represent you, I will. You said no 3-4 times to me. If you want me to have a lawyer sit by and help you during the course of trial, I will. But I'm telling you, you're not going to show your anger in here. And I didn't talk to Judge Hesselink about this, but I've heard enough from staff members. Anger doesn't go well with jurors. And I'm not going to put up with yelling and screaming and blurting out and doing these other things that were expressed to me that you did. You want to represent yourself? That's fine. But I want to caution you are going to hurt yourself. That booking video, whether you think you're right or not, showed the extent to which you have an anger issue, and that's fine. It's fine. Everybody has issue. It's not going to help you. It is not going to help you. And I'm here to caution you that no juror in the land appreciates people acting disrespectfully and within. Now, I'm going to ask you one more time. Are you sure you don't want a lawyer to represent you? Pardon me?
I'm sure I don't want a lawyer.
Are you sure you don't want a lawyer assisting you during the trial?
No, sir.
Okay, now, so then let's get this straight. You understand you're going to have to conduct yourself profession, right?
Yes.
You understand I'm not going to put up with that nonsense that I hear went on in the other courtroom, right? You blurting out in front of a jury like that is absolutely outrageous. I've been in.
I was being suppressed.
Don't tell me this. You don't act like that. You have the right to appeal. Greatest system in the world. You have the right to appeal. You have the right to advance arguments on appeal, but you do not have the right to act unprofessionally. I wouldn't put up with it from a defense lawyer, a prosecutor, a police officer, and I can promise you I'm not putting up with it from you. And I'm trying to tell you, for your own protection, I'd like you to reconsider having a lawyer. Have you responded to all of her arguments?
I was just handed a number of motions this morning.
I'm not putting up with this motion filing garbage all the time either. What's the substance of the new motions? You can't just come in and give prosecutors a motion hearing on the date of the hearing and expect a judge to hear it. I read this, believe it or not.
Well, I could have mailed it to her, but she just responded to my motion to disqualify her yesterday, and so I prepared my.
Because you didn't file it till what date you file it? The 18th it was timestamped. Yesterday was the 19th. When did you want to respond? On the 12th?
I mean, she gives me the discovery 12 days later.
Ma'am?
The night before court. And this isn't the first time. She's always giving me discovery the day before court.
You filed a motions on the 18th. That's inappropriate. I could quash the motions and not hear them. That's not appropriate notice. Read the court rules. You want to represent yourself, you're going to have to read and understand the court rules. And that's the problem. You can pull things off of AI, but you need to understand when you filed, you claim she was proceeding under state law. She wasn't proceeding under state law. That's what I'm talking about, but that's fine. Everybody wants an adjournment. I'm fine with an adjournment. I'm setting a date for filing all motions, and that's it. There will be no other motions until we have the jury trial. So, I didn't get a chance to read any of yours, and frankly, ma'am, I didn't get a chance to read whatever reply you had today. You can't just walk into the courthouse and give us these. All right, I'm going to make a note. Defense requested motion, adjournment of motions. Is that what you're requesting, Ms. Phillips?
Yeah,
Okay.
because I just received discovery yesterday. The rest of the
Okay, that's fine. That's fine. And you addressed all.
I did, Your Honor. If I could briefly address discovery, I know there's allegations that I didn't provide it within enough amount of time. I had an informal conversation with Miss Phillips at the very beginning of this hearing trial. She asked for discovery. I'm always good about giving discovery. I did body cam, I did the incident report, I provided those to her. That was back in June. And then on the 31st of July, I received a motion to compel discovery, enumerating a volume of items that my office doesn't maintain or retain. So I got that list over to the Brownsville County Police Department. They got that to me yesterday, and I uploaded that all to Miss Phillips within the 21 deadline for that discovery. Thank you.
I've never found you uncooperative with defense lawyers, defendants, or anybody else. So let me be clear. I've never found you slightly misrepresent anything to this courthouse. Not in this courtroom, you haven't.
Thank you.
Now, we're going to proceed in an orderly fashion. We're going to set a new jury trial date because I can't possibly get all this in and have a jury trial date. Now, I want to save you some time, Ms. Phillips. Let's first pick a motion hearing date, Heather, and a jury trial date in October. Let's give me a jury trial date in October first.
Okay, let me take a look. How about our first Friday of October is the October 2nd?
You know what? I think I want to go later than that.
Okay.
I think what
So we have 5
I'm-
Fridays in October.
I'm thinking the 2nd, 9, 16, 23 is 30th, the last day.
That's correct, Judge.
We're going to set a jury trial date of October the 30, unless either one of you are not available at 8:30 in the morning. Are you available?
I'm available.
Are you available? Jury instructions are due. Because I just have a feeling I might have more of a problem on this one. They're due by October the 16th. I'm hoping you two will exchange information. Are you gone?
Your Honor, but I know that generally I always work with opposing counsel or defendant about putting together stipulated jury instructions. We had a very hard time getting those together down the hall. So I don't know if we'll just need to file our own and then have some sort of meeting beforehand to hash through our disagreements about the.
What do you want? What date do you want?
I just don't know that we'll be able to stipulate to jury instructions.
Yeah, I don't think so either. We're going to make it October 9th, the jury instruction they're due. Now, give me a date, Heather. I'm thinking unless somebody has. What do I have 2 weeks from today, Heather?
2 weeks from today, we have.
I'll tell you what, let's
Flat
make
Rock
this
here.
easier. I don't want to rush this. Give me a date 4 weeks from today.
Okay, that would be September 17th, and we do have Miss Foley Carter here that day.
We're going to do motion date will be September 17th at 11 o'clock in the morning. All motions due by September 7th and must be served on opposing counsel. Now, that's what I'm going to do. So motion hearing date, final pretrial will be September the 17th. Jury instructions due by October 9th. And I want another date the following week, review of jury instructions to make sure everybody's all set on that. And that should be October the 16th or 15th.
Let's see here. That would, oops, sorry, you said October, that would be
15th.
October 15th, yes.
October 15th, and that'll be at 11 o'clock. So you're going to get 3 dates, and you have to write down your jury instructions that you two are going to hopefully agree on by October the 9th. We're having a final pretrial and motion hearing September 17th at 11. All motions are due by September the 7th. Responses due.
17.
No, September 7th. We're having a motion hearing date on the 17th. Responses due by September the 14th by noon.
Okay, so all motion responses.
Due by September 14th. Motions are due by September 7th. Motion date will be September 17th at 11. Jury instructions are due on October the 9th. Review of jury instructions to make sure we have everything in order, October 15th at 11. Jury trial date October 30th at 8:30. I'm taking all these home. I'm not gonna, pardon?
October 30th.
Yes, that's the jury trial. I'm taking all these home. I can tell you, I'm not gonna grant your motion to dismiss for reasons that I've stated on the record. I want you to know I did look at the video. I want you to know I didn't even read any of this, these responses on this. You didn't have a response until this morning, and rightfully so. You only got it on the 18th. She's right. I'm not gonna let anybody talk about the fact she was charged with or convicted of stalking and or telephone harassment in front of Judge Hesselink last week. So we're not going to bring that up. There was a second component of that. I think that it's appropriate only that the jury be instructed that, or in there, and I'm going to allow testimony that she was in there for purpose of submitting the fingerprints pursuant to a court order, but there will be no mention of the charges. No mention of what the charges were.
I understand, Your Honor. I conceded that point in my.
You did? Okay. And then what were the other things she brought up? What was the other one I tended to agree with you on? What was your second point?
What
was
the motion? You're talking about the motion in Lamine?
Yes.
Let me.
At any rate, I can go over all those with you. Listen, guys.
So you said you watched the video?
I did.
Okay, and you feel like I deserve to get beat up or busted lip and all
Now,
that?
see, like if you pull that
You saw me swinging and hitting the police?
if you start to, first of all, let's become abundantly clear. I'm not a witness.
No,
I'm not a witness here. Do you understand what I'm telling you? And if you pull that nonsense with me in front of the jury, listen to me, look at me, you're going to end up in the back. Do you understand what I'm telling you? You are proceeding in peril of significantly affecting your life because of your anger issue and your lack of any respect for authority. It was abundantly clear to anybody watching that you were simply going to be uncooperative. Now, whether they were justified in their actions is a question of fact for the fact finder here, the jury.
I was uncooperative.
Did you hear what I said?
I did.
All right, don't argue with me.
I'm not arguing.
You are not to argue with me. They do not pay me enough money to argue with you.
Okay, sir.
You got it?
Are we done here?
No. No, we're done when I say we're done.
Okay.
But I'm telling you, you are going to get yourself in a lot of trouble. You act anything like you acted down there, I'm telling you, you're going to end up in the lockup. And no, I'm not done.
Okay.
I said I will tell you my reasons, but you're not going to argue with me when I make a ruling. Here, at the time of the jury, or any time during the course of this case. Frankly, your stalking and telephone harassment are much more serious charges.
I was wrong.
And you're going to get to deal with those.
And she.
So I was simply going to suggest that the two of you might wish to figure out a way to resolve this. I can tell everybody wants a trial, and that's fine. That's what I'm here for. But they do not pay me enough to argue with you. They don't. They never will. And if you raise your voice with me like that again, you are going to find yourself in severe jeopardy. Do we understand one another? Good. Case is adjourned until I can hear and read these motions. Watch your mouth. Come back here.
Just don't sit down.
Get back here right now. What did you say?
I said, have a great day.
You better watch your mouth. You think I'm going to put up with the nonsense that you gave them in the police department? You are dead wrong. I know you didn't. You don't think you do. You have a serious anger issue. I know. Now leave here quietly. If I hear that thing bounce out of there, you're going to end up in the back.
Oh my God, I've been muted. I shouldn't have been muted. Oh, I can't believe that happened. It's been a crazy night. Judge Dad got so mad right there. Thank you so much for all of the super fun little thingies, the super chats. Everybody who's been here to hang out. X25, I'm going to get some now. I'm your lone wolf Boostle. I am out.
And remember, only you can take a bite out of crime.
Bye.